that based on this court's precedent in the due process space and principles of entrapment by estoppel, maybe they have a sufficient safeguard here to allow them to continue to operate. I would think even before non-enforcement policy were announced, of course, the president-elect would want to review all of the updated national security information that has come in over the last 4 years that undergird Congress's judgment here. But the final thing I would say is that even if you think the third-party providers are simply going to choose not to continue to provide these services because it's too much of a risk to take on, again, that's not anything permanent or irrevocable, and that might just be what the PRC and ByteDance need to start taking seriously some of the public reporting about interest in acquiring the company. So I think that's a really illuminating exchange, given the posture that we're in right now with an anonymous, official from Biden's administration saying they're not going to enforce. That seems insufficient. But we'll see what happens today, and we'll see if things get a little bit more clear. So we have about 30 minutes until the decision comes down. So I can answer your questions. We can talk through the arguments that were made. We can talk through what possibly happens from here. So for those also who are new here, and we do this every time there's an opinion, there are few rules of the road on opinion day. First, typically the justices take the bench if they're in session. The court was adjourned after Wednesday until this next Tuesday. Typically the justices take the bench and they will read aloud sometimes from the decision or a summary of the decision. Today, inside the court, whoever is choosing to go into the media room, the press office, they will wait for the press officers there to bring out boxes of an opinion. We don't know what it is when it's in the box. It's a covered box. And we wait until exactly 10 a.m. and they give physical copies to members of the press inside the press room in there. The problem is you can't go live from inside the press room. You could tweet, but you can't stream or be on TV or anything like that. So that's why there's what's called the running of the interns, where interns will be inside grabbing a physical copy of the decision. They'll run outside and hand it to people who are waiting out here with all of the media, which I can give you guys. Look, there's a lot of media all right out here right now. And I am also that, so when we get a decision, I will also have to stand up and do a live hit shortly after that, but I'll talk you guys through it. Yes, it will be posted to the Supreme Court website. So just finishing out how opinions work. So at the moment that they are releasing a physical copy in the room, they're also uploading an electronic copy to the Supreme Court's website. So if you want to follow along and see what the opinion is, you can. Just go to supremecourt.gov and then click opinions in the top left and then click opinions of the court. And then you'll be on a page. You'll see Wednesday's 2 opinions that came down already. And at 10 a.m. on the dot, we all just start hitting refresh. That's what happens. And then we'll get it, and then I'll talk you through it. A couple of other things. If we get more than one opinion, like we did on Wednesday, the column, let me show you on the court's website. This is what it looks like on the opinion page, the opinions of the court. So the column here that has R at the top, that will be filled in once we have the final opinion of the day. So if it's empty, if it's blank, then we know we're getting another opinion. But I'll tell you right away if I know we're getting more than one opinion. The other thing is they're released in order of reverse seniority of the justices. So, for example, I think it was Kavanaugh's opinion came out first on Wednesday, followed by Justice Kagan, of course, because Kagan is senior to Kavanaugh. The chief is the most senior, even though he hasn't been on the court the longest. That's Thomas. And so you can sometimes read the tea leaves and discern, if only the chief is remaining and it's a multi-opinion day, it might be a big one because the chief has a tendency to take on, they're all important opinions, but some of the really hotly contested major issues. So that's kind of how opinion day works. That's what'll happen at 10 o'clock. But I can save you all of the work because I'm going to do all of that and I'll walk you through exactly what's happening. Would an injunction or administrative stay be in an opinion? Yeah, that's a great question. So there are three options of what could happen today. We could get an administrative stay, we could get a preliminary injunction, or we could get a decision on the merits, meaning the courts could decide one way or the other whether the law is constitutional. So, and there are different ramifications for each of those things. And Justice Alito, toward the end of oral argument on the 10th, asked about, there are lots of helicopters and police going around, of course, because we're also right across from the Capitol. And you can see everybody's getting ready for inauguration. Also, that dog is pooping, so. You don't usually see helicopters going over the Supreme Court, so we're just getting ready for inauguration here in DC. Anyway, okay, so the ramifications of an administrative stay versus a preliminary injunction. So an administrative stay is used by the court when they just need to press pause and give themselves a little bit more time. It often comes up during an emergency request where somebody rushes to say, we have this major issue, this lower court made this decision and it's going to mess everything up. Please, can we have an administrative stay? And the effect of an administrative stay is literally to preserve the status quo. It just freezes time and place. And if we got an administrative stay in this case, it would basically pause the law the ban from taking effect. It's important to note the law is already in effect, right? The clock has already been ticking. It's the ban that would take effect. So an administrative stay would pause that. And the court doesn't have to tip their hand about what they're thinking substantively about the case in an administrative stay versus a preliminary injunction. A preliminary injunction is different. And in fact, this just came up in the Texas porn law case on Wednesday. But when the Supreme Court issues a preliminary injunction, or any court, there has to be a finding that the requester is likely to succeed on the merits. Meaning here, if TikTok were to get a preliminary injunction, the court would essentially have to say, well, it's likely the TikTok and their First Amendment argument is going to ultimately succeed, so we're going to enjoin the law, but we're still going to work on an opinion to come out later. Now, it's not absolutely that TikTok wins, but it is tipping their hands on what they think about the merits of the decision, that there is a likelihood of success on the merits. And so there was also some discussion of whether there could be some sort of hybrid preliminary injunction, administrative stay, something that pauses the case or enjoins the ban, but doesn't require the court to tip their hand on what they think ultimately about the merits. It's possible that we get that as the decision today and not a merits decision. So that's one of the three. Those are the three options. Yes, I have gloves today. For those who were here on Wednesday, they know my gloves were not cutting it. Okay, let's see. Can I? Okay. Yeah, I'm drinking a lot of Starbucks so that I can just be super ready to read this opinion. What do I think will happen? Okay, so right after oral argument, I thought we were headed towards some sort of administrative stay and preliminary injunction, especially because Alito was asking that question toward the end about, are we able to issue an administrative stay? And he was asking those questions because the posture of the case is not really one where the court would typically enter an administrative stay, because it has been fully briefed, fully argued, and submitted. At the end of every oral argument, the Chief Justice says the case has been submitted. So it would be kind of square peg, round hole to do an administrative stay, but also the rule of the Supreme Court is they can do as they please. And so they could do something like that. So I was thinking we were headed towards some sort of pause. The fact that we haven't gotten one by now, you honestly could read one of two ways, right? You could read it as the court actually agreed. They're going to uphold the law. It's unanimous, and that's the decision we're getting today. There are some really thorny issues that the court would have to get into that they may not want to get into. And so maybe they've been grappling with those for a week and realize, look, we're not going to get this kind of opinion written so quickly. So we do need to pause and give ourselves more time. So I could read that truly either way. But if you asked me on Wednesday, it seemed like we were headed more towards a decision on the merits because they hadn't issued an injunction or a stay yet. But as with everything with the court, you just take your best guess and you never know for sure until they actually do it. how long could we expect an administrative stay to last? Yeah, that's another good question. I mean, they may be pausing things, one, to work on the substance of their opinion, which has some really thorny issues about First Amendment rights and how it applies here. And you remember Justice Amy Coney Barrett asked during oral argument, actually, is there a way that the creators who brought the suit win and TikTok doesn't? So it might be that the creators are actually putting forward a right because they're the ones creating and speaking directly, versus TikTok, who's kind of they are a media company, right? They compare themselves to the Washington Post, but it may be a stronger argument from the creators that they are having their rights violated. There's also a conversation. I don't know if you guys can hear me over the helicopter. Hopefully you can. This is wild. We don't ever see this. Just us getting prepared for inauguration. Lots of security prep going on. But no, typically that nobody can be in the airspace over the National Mall. The other thing that came up during oral argument was part of the First Amendment issue is not just the expression that's happening and the publication and the newspaper adjacent role that TikTok is conducting, but it's also the right. Americans have the right to receive information, even if that's from the Chinese Communist Party, and the U.S.-based Communist Party is just parroting talking points directly from the Chinese or from the talk about Americans have the right to receive information. So that might even be a stronger right than the one that TikTok is putting forward. Hopefully that answered your question. I think I went further than the question asked, but wow. It's just going to be constant, but I'm glad you guys can hear me. Kind of annoying, but I get it. Gotta be safe. Am I what? What's my question? What is the question? Yes, 10 Eastern. We're expecting the decision. So T-minus 22 minutes. For those who are new and just joining, I'm Katie with SCOTUSblog. This is what we usually do for every opinion day, but welcome. I understand there's perhaps more interest in this one, given the platform. But this is what we always do. We are the only ones who go live as the opinion comes down. It can be dicey because sometimes opinions are complicated, and I read them to you as is and try and interpret them live as it's going on. Everybody remembers the Obamacare case where everyone kind of scrambled because it seemed like maybe they struck it down, but then they upheld it as a tax, and that got complicated. So I think there is some general hesitation to do this, but we do it. Sometimes it takes me a minute to talk through things, but this may be one that is pretty straightforward. I'm trying to think of the most recent kind of more complex case. I think the immunity decision, because of its kind of three different areas of protected presidential behavior, that took a bit of nuance to explain, because you couldn't just come out of the gate and say, yes, he has absolute immunity. No, he doesn't. But anyway, we always do this. I'll talk it through live. Nobody else does that, so it'll be fun. If it's banned, does it set a precedent to force the sale of any foreign-owned companies that's deemed a threat? Yes, that came up during oral argument, that's a concern, right? And in the press section, a number of our publications got name dropped throughout the course of oral argument. Politico was one of them, who is German-owned. And so there was a hypo about, well, what if they decided, Congress decided we didn't want a German-owned company? Could they go after Politico? And that seems like more in the heartland of, violating the First Amendment. But TikTok's argument is, hey, we're just like them. We're just like the Washington Post. We make editorial decisions. We put out this content. We curate this content. We are the modern day newspaper and news source for, I think, a lot of people, which is quite literally what we're doing right now. The other hypo that I think was helpful during oral argument, there were lots of hypotheticals about newspapers and news companies. But one of them was, could Congress force Jeff Bezos to sell the Washington Post? Or divest from the Washington Post. That one's a little different because part of the conservative justice's argument here is this isn't about the First Amendment at all. This is about ownership, and the ultimate ownership parent company is a Chinese company, and they don't have First Amendment rights, whereas obviously Jeff Bezos would have First Amendment rights, slightly different. But the point of that argument is, this is the danger here for whoever asked that question. Would it set a precedent for being able to go after other companies? Hi everyone who's joining. Welcome. Welcome to what we do every Supreme Court Opinion Day, but I suspect you're here because this one is of particular interest to you. Can I explain the pro-TikTok First Amendment arguments? Yes. So TikTok is arguing that the law violates their right to freedom of expression, both as this compiler of, they basically are functioning as a newspaper, right? They are providing content, they're curating that content, they're editing that content, they're heavily involved in the algorithm and how things are displayed. And they function like a modern day newspaper. And so it would violate their First Amendment right for Congress to say, hey, you can't do that, or this is how you have to do that, right? And and part of the discussion during oral argument is, whether the law is doing that or whether that's merely incidental to a law that's really just about ownership and targeting a national security interest. The argument the creators put forward is that plus. The creators are the ones who are actually putting the content online. And they also, I think this is what I was just talking about with Justice Amy Coney Barrett, put forward this argument that they have the right to receive information and content on TikTok, and that the government, by passing this law, is imposing on that part of their First Amendment right. So it's kind of a hybrid. And there, as the lawyers argued, Jeff Fisher, for the TikTok creators, there is a way that the creators win, but TikTok doesn't. And so, sorry, I'm just getting multiple notifications on my phone. T-minus 17 minutes, by the way. So that's also possible. Maybe the creators win here, and that is an ultimate win for TikTok. For those who are just joining, welcome. I want to talk through the enforcement point again, because I think it's an important one. So again, Biden, an anonymous official, has said they wouldn't enforce the law. And Trump is perhaps not going to enforce the law. We don't know that for sure. The problem is these third-party service providers who would be subject to the law and fined under the law immediately, because that's who the law targets, the people who provide the technical infrastructure for TikTok to continue to exist, the Apple Store, the engineering, all of the background stuff that makes it exist. They would be the ones harmed. They would be the ones that would be a problem if there was some sort of bait and switch on enforcement. And so during oral argument, Justice Kavanaugh very smartly brought up that point, and had an exchange with the Solicitor General. And I'll read it again because I think it's an important one, because this is going to be the next question. If the Supreme Court upholds the law, but the president and the next president say we're not going to enforce it, there's still an issue here. And whether or not those companies who provide the background support for TikTok are going to feel confident enough to rely on that statement of non-enforcement before they violate the law, right? They would be violating the law that would subject them to very expensive penalties. So this is the exchange with Justice Kavanaugh during oral argument that kind of gets at that, and the Solicitor General's point about due process. So Justice Kavanaugh asked, would that then adequately, that would be binding, in other words, protect the regulated community, that's the third-party service providers, such that it could rely on due process principles rely on that under due process principles going forward. The Solicitor General says that raises a tricky question. So I think there would be a strong, and then she gets cut off by Justice Kavanaugh. Well, then it's not going to be adequate, right? He's talking about the ability of the third-party providers to rely on some sort of due process argument if they violate the law because the president says they won't enforce. So the Solicitor General says, well, I think there's a strong due process argument that the third-party service providers could invoke if there were enforcement action, meaning if the president changed his mind and decided to enforce the law, if there were enforcement action based on a period of time when the president said the law wouldn't be enforced, the kind of canonical case, she says. And Justice Kavanaugh says they're not going to take that risk unless they have the assurance that a presidential statement of non-enforcement is, in fact, something that can be fully relied on because the risk is too severe otherwise, right? And that is, I think, illuminating because we don't have... Oh, yeah, okay. I have to turn my mic on because we're getting close. I'm still walking through the enforcement point. Hang on. Let me turn on my mic. Is my IFB... I don't... Turn my IFB on. Okay. Oh, it must have fallen off. Yep, it fell off. Hang on, guys. I just gotta put my IFB in. I'm gonna have to go live in my other job if we get the decision. But I'll keep you guys around. You can see what we do. Okay. Turn that down. I'm just gonna turn it way down. Will you let me know if they're talking to me? Okay. So the fact that there's only been an anonymous official in the administration, the Biden administration, and Biden hasn't made some public comment, unless I'm incorrect about that, but that's the latest I understood, that's probably insufficient for the third-party service providers to rely on that, an anonymous source, to go forward and violate a law. So there needs to be some sort of clear statement if the court upholds the law today in order to be able to deal with what Justice Kavanaugh and the Solicitor General are talking about. There would need to be some sort of clear presidential statement, full-throated, directly from the president. I'm not going to enforce this law. But I'm going to read Solicitor General Prelogger's response, which maybe captures how the Biden administration is thinking about it. So she says, I think that they might judge that based on this court's precedent in the due process space and principles of entrapment by estoppel. Entrapment by estoppel, basically bait and switch by the government, right? The government says, we're not going to enforce, entrap them, and say that we're not going to enforce, and then change our minds and enforce. She's saying that there would be a due process argument there based on this court's precedent and the principles of entrapment by estoppel. Sounds like a good book title, by the way, if any of you want to write a super nerdy book title. Maybe they have a sufficient safeguard here to allow them to continue to operate. I would think even before a non-enforcement policy were announced, of course, the president-elect would want to review all of the updated national security information that has come in over the last 4 years that undergird Congress's judgment here. But the final thing I would say is that even if you think the third-party providers are simply going to just not continue to provide these services because it's too much of a risk to take on again, that's not anything permanent or irrevocable, and that might just be what the PRC and ByteDance need is thinking. The problem is it's only going to be the Biden administration for a little while longer, so there would need to be some other sort of clear communication, declaration, what have you, from the Trump administration. Because, of course, Trump's Solicitor General, Pick, wrote a brief to the court in this case, but he didn't speak in this case because they're not parties. It is cold out here, but it is not as cold as it was on Wednesday. So welcome if you guys are new. We're about to do opinions at the Supreme Court T-minus 9 minutes. The way it works for us is we will go to the Supreme Court's website at 10 a.m. and hit refresh until the opinion drops. We don't know how many opinions the court will release today. It's one or more decisions. We'll find out together. And if you're following along on the Supreme Court's website, just click opinions in the top left, then click opinions of the court, and that's the page you refresh. We'll know if we're getting more than one opinion after the first one drops because the R column, if it does not have a number, that means we're getting more than one opinion. If the R column has a number in it, as they all do right now, that means that's the only opinion of the day. And because we already got 2 opinions this week, I would be surprised if we got 2 more. It's still early January. The justices have only been hearing arguments since October. So, like I said, we're in the preponderance. I think it's more likely than not that it's the TikTok case, but it's certainly not guaranteed. Yes, there's the helicopter that keeps circling. Hopefully you guys can still hear me. It is kind of nonstop. They can be called opinions and rulings and decisions. They're talking to me. So hang on, let me turn my IFB up. Hello? Chris, are you talking to me? Yes. Do you have my mic? You got me? Okay, great. So I'm gonna keep talking. I'm just talking through on the live stream, and then if we get it, I'll let you know when I'm ready to go live after I read as much as I can. All right, I'm gonna turn them back down. Will you let me know? What? Wow, so many questions. Hang on. My Starbucks drink of choice is black coffee. Today is a decision day in just about 7 minutes. It's not like a burden of proof case, Kim. I was just saying, I was making a nerdy legal joke. Preponderance just means more likely than not. And I was saying it's more likely than not that we get the decision today. It's not like applies to the meat of the case. Let's see. I will get the opinion electronically, not running of the interns. I used to be one of the interns running the opinion way back in the day. Yes, I am an attorney at the Boss Esquire, for those who are asking. I went to Georgetown Law just up the street from here. But now I'm a full-time journalist. You're welcome. Thank you.
I got you.
They haven't started yet, so they'll start right at 10 o'clock. Inside, the press office will release physical copies of the opinion right at 10 o'clock. All of the members of the press who choose to be in there, now not as many because they don't have to be because it's electronic, but all of the press members that choose to be in there will be inside waiting for a physical copy of the opinion from the press office that they literally take out of the box and hand to you at 10 o'clock. So all of that is happening inside the court behind us, but out here, thankfully, because of the pandemic, we get to be able to do this all electronically. Unfortunately, the Supreme Court doesn't live stream the audio of their oral arguments. They have not made that decision for whatever reason. I mean, for their opinions, they do live stream audio for oral argument, but not opinions. But I don't believe that they are going to take the bench today to release the decision. They also are meeting for conference today, and conference is T-minus 5 minutes, by the way. It's your 5-minute warning. Conference is when the 9 justices go into a room. Nobody else is allowed inside that room. Not even clerks, not secretaries, not even a note taker. The most junior justice is responsible for taking notes in the case and for getting the door. So if a justice forgets their glasses and a clerk brings them to the door, the most junior justice, Justice Ketanji Brown Jackson, has to get the door and is responsible for taking notes in that room. So when they go in for conference today, they will consider all of the requests that are pending right now for cases that they could take up. One of them I'm keeping an eye on, because I'm also a local reporter, is there's an assault weapons ban out of Maryland that they're considering whether to take up. So that's also happening today. So if for some reason this opinion isn't TikTok, I think it is, but if it's not, the court meets for conference and we could get some decision out of conference related to it later today. And they don't give us timing on orders out of conference. And sometimes they don't even put orders out on Friday. They typically put them out the Monday after conference, but sometimes, like last week, they put out 3 new grants in new cases. So 4 minutes to go. Opinions are released in reverse order of the justices. So if we're getting multiple today, the most junior justice will go first. I would expect the chief to probably have this one. The way it works for opinion assignments is after they vote in conference, the room that I was just talking about, the most senior justice assigns who writes the opinion. And if there's a dissent, then the most senior justice in the dissent decides who writes the dissent. The chief is always the most senior, no matter what, even though he hasn't been on the court the longest. So if the chief is in the majority, he can assign the opinion to himself. Oh, hang on. Let me turn my IB up. Hang on.
You good? Perdón?
What is happening at the top for 3 minutes?
Just a bump
Oh, a bump shot. Okay, great. Okay, thanks.
No escuché.
Sorry, they're talking to me in my ear. 3 minutes. All right.
Don Carlitos, ¿cómo estás?
So
Bien,
I will also
bendecido.
say it has happened before that we crashed the Supreme Court's website because everybody's trying to refresh at the same time.
La verdad, un gran
That
día.
also has happened. Hopefully that
Comparado
doesn't
con lo
happen
que hemos
today.
tenido y tendremos.
2 minutes. Time for your regular Amtrak joke if you ride Amtrak from DC to New York.
Uy, bien frío.
2 minutes. 2 minutes. My name's Katie.
¿Pero de dónde eres tú?
Lots of people asking who am I? I'm Katie. I'm with SCOTUSblog. I'm a
Uy, no,
lawyer,
hermano.
but I'm a journalist.
Ya estás curtido.
Both.
Exactamente.
All right.
Exactamente.
So I'll talk you through what we get when it starts to come down. Though on Wednesday it took about 90 seconds for the first opinion to come up because they're putting it through to upload. So it may take a second. It has also happened in the past that they put up a document that has some sort of error. So it's not going to happen at 10 a.m. on the 2nd, but it will happen likely shortly thereafter. But like I said, the next part of this conversation, if the court upholds the law today, becomes the question about enforcement. And that's the exchange with Justice Kavanaugh and the Solicitor General. And that will be the next part of this conversation that we're all going to be talking about if the court upholds the law today. So that's important. And we'll talk about it afterwards, depending on what the court decides. All right, we got under a minute. And you will literally just hit refresh over and over again. If you want to follow along on the court's website or on SCOTUSblog's live blog, you can go to SCOTUSblog.com, or you can go to the Supreme Court's website and click opinions in the top left, and then opinions of the court, and then you just hit refresh over and over and over again. All right, it's 10 a.m. Here we go. It got eerily quiet right around here. It's because we're all just hitting refresh.
Perdón.
It's not up yet. If you guys get it before me, of course, let me know.
No entendí.
How much coffee can I physically drink before the decision comes down? That is the challenge now. All right, TikTok v. Garland, that's the decision. It's a per curiam decision, meaning the court is speaking with one voice. There's not one individual justice. It's coming up. Hang on. As of January 19th, the act will make it unlawful for companies in the United States to provide services to distribute, maintain, or update the social media platform TikTok unless U.S. operation of the platform is severed. In doing so, we consider whether the act as applied to petitioner violates the First Amendment. In doing so, we are conscious that the case before us involved new technologies with transformative capabilities. This challenging new context counsels caution on our part. As Justice Frankfurter advised 80 years ago, in considering the application of established legal rules to totally new problems raised by airplane and radio, we should take care not to embarrass the future. The caution is heightened in these cases given the expedited time allowed for our consideration. Our analysis must be understood to be narrowly focused in light of these circumstances. There is a dissent concurring in the judgment. Hang on. The judgment of the United States Court of Appeals for the District of Columbia Circuit is affirmed. That means they're upholding the DC Circuit's decision, which said the law is constitutional. But let me keep reading here. Hang on. TikTok is a social media platform that allows users to create, publish, view, share, and interact with short videos. They don't have a straight up holding here, but it looks like they affirmed the DC Circuit, which upheld the law. Since its launch in 2017, blah, 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 opening TikTok application, TikTok's users. In recent years, the U.S. government officials have taken repeated actions. Against this backdrop, Congress enacted the law. ByteDance and TikTok, along with 2 sets of TikTok users and creators, filed petitions for review. The DC Circuit consolidated. We granted cert to decide whether the act as applied to petitioners violates the First Amendment. At the threshold, we consider whether the challenge provisions are subject to First Amendment scrutiny. Laws that directly regulate expressive conduct can, but do not necessarily trigger such review. It's not clear that the act itself directly regulates protective expressive activity or conduct. This is the question about whether it's about ownership or about regulating expression. And it directly regulates ByteDance and TikTok only through divestiture requirement. Petitioners, for their part, have not identified any case in which this court has treated a regulation of corporate control as a direct regulation of expressive activity or semi-expressive conduct. We hesitate to break new ground in this unique case. In any event, petitioners' arguments more closely approximate a claim that the Act's prohibitions, TikTok's specific designation, and divestiture requirement impose a disproportionate burden on their First Amendment activities. Petitioners assert that the government does not contest that because it is commercially infeasible for TikTok to be divested within the Act's 270-day timeframe, the Act effectively bans TikTok in the United States. We have recognized a number of these asserted First Amendment interests. At the same time, a law targeting foreign adversaries' control over communications platform in many ways is different. This court has not articulated a clear framework for determining whether a regulation of non-expressive activity. We assume without deciding that the challenge provisions fall within the category and are subject to First Amendment scrutiny. They've identified 2 forms of content speech regulation as applied to petitioners. The challenge provisions are facially content neutral and are justified by a content neutral rationale. That's a loss for the TikTok argument. The government also supports the challenge provisions with a content neutral justification. For the reasons we have explained, requiring divestiture for the purpose of preventing a foreign adversary from accessing sensitive data of 170 million TikTok users is not a subtle means of exercising content preference. On this understanding, we cannot accept petitioners' call for strict scrutiny, so they're not applying strict scrutiny. No more than intermediate scrutiny is at issue. Not yet. Not yet. Meaningfully dispute the scope. Even if China has not leveraged the relationship, hang on. Petitioners parade a series of alternatives. Okay. There is no doubt that for more than 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, means of engagement, and a source of community. But Congress has now determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. For the foregoing reasons, we conclude that the challenge provisions do not violate petitioners' First Amendment rights. All right, we can go. Guys, I'm gonna stay with you. I just have to go live on TV for a second. Yeah. You can come to me. We have a commercial break. The court was dicey about what scrutiny they were applying. Okay. Okay, that's fine. So you're gonna do commanders first, then me. So it's gonna be a minute. Oh, okay, gotcha. Okay. Justice Sotomayor concurred I see no reason to assume without deciding that the act implicates the First Amendment because our president leaves no doubt that it does. This was actually her opening questions. She agrees that the act implicates the First Amendment. So she wrote a very brief concurring decision there. Justice Gorsuch also wrote separately saying, we've had a fortnight to resolve finally and on the merits a major First Amendment dispute affecting more than 170 million Americans. Briefing finished on January 3rd. Argument took place on January 10th. And our opinions issued January 17th. Given those conditions, I can sketch out only a few and admittedly tentative observations. First, the court rightly refrains from endorsing the government's asserted interest in preventing the covert manipulation of content.
Fuera del control de ByteDance, que es esta compañía china. Esto pues tiene varias implicaciones. Sabemos que la administración Biden ha decidido no incurrir en las multas que tendrían que colocarse a estas empresas que pues tienen la aplicación en las últimas horas de su mandato. Sabemos que el presidente Biden deja de ser presidente el mediodía del lunes 20 de enero. Entonces quiere decir que desde que
I'll go back to reading the decision just a second.
Es el primer minuto del domingo hasta el mediodía del lunes son 36 horas que la administración Biden básicamente ha decidido no poner estas multas, que no entre, pues digamos, el castigo a quienes no estén aplicando esta prohibición. Pero entonces viene ya la decisión de lo que podría pasar en la administración Trump. Sabemos que el presidente electo Trump en su momento le pidió a la Corte Suprema pues más tiempo para poder él maniobrar. Sabemos que hay esfuerzos también pues de empresarios para tratar de comprar esta aplicación, y sabemos incluso que esta mañana el presidente electo Trump habló con el presidente chino Xi Jinping refiriéndose entre otros temas al de TikTok. Vamos a ver qué viene hacia adelante. El margen de maniobra realmente es limitado, porque si bien un mandatario puede emitir órdenes ejecutivas, las órdenes ejecutivas sirven para explicar, para delimitar, para clarificar las leyes.
Hey Steve, so the Supreme Court today in a per curiam decision, that means the Supreme Court is speaking collectively with one voice, not any individual justice, upheld the law. They also lamented the fact that they basically had a fortnight, as Justice Gorsuch refers to it, in his concurring opinion, to decide all of this. All of this was really quickly done. They talk about that throughout the decision, but the bottom line is they are upholding the law, and they said they're assuming, without deciding actually, that the law even affects the First Amendment rights of TikTok and the creators on TikTok. They didn't even reach that ultimate decision. They just said they assumed without deciding that it affects their First Amendment rights in upholding the law. So bottom line, at the end of the day, the Supreme Court is upholding the law. Now, what happens next? Well, anonymous official in the Biden administration has said that they will not enforce the law. But there are some problems with that, because the third-party providers, who are the ones who are going to be subject to the penalties in this law, they're the ones who service TikTok and provide the background infrastructure and the app updates and the Apple Store and all of those things. They're the ones who would get penalized, and I don't think that it is sufficient that they would rely on an anonymous source from the Biden administration in order to actually break the law. They're going to need a clear presidential statement from both Biden and incoming President-elect Trump. That discussion actually came up during oral argument. Justice Brett Kavanaugh brought it up during oral argument and said there will be some real concerns here, even if the president said they're not going to enforce the law. So over the next 48 hours, we're going to see what comes out of the White House about clear enforcement and what comes out of the president-elect's camp about clear enforcement of the law. But as of today, that ban that's set to take effect on Sunday, January 19th, we're headed towards it.
Can I call you back? We're on this road.
So the way that the law works is the DOJ will enforce the provisions in the law that penalize these third-party servicers that I'm talking about. So yes, technically TikTok could continue to exist, but all of these companies who provide these services to TikTok would have to be willing to risk losing millions and millions of dollars in the penalties that they would be subject to for violating the law. So yes, technically TikTok could continue to exist, and if those companies feel comfortable relying on anonymous sources or even a president saying I'm not going to enforce the law through my Department of Justice, then it may continue to exist. And it looks like that's what everyone generally wants to happen, but I think that there's going to have to be some more clear statements out of the White House and the incoming White House officials before we actually see some concrete progress there. Yeah, no problem. All right. Let's read the decision, shall we? Hi, guys. If you're just joining, Supreme Court upheld the law. They assumed without deciding that it implicates the challenger's First Amendment rights. And then they basically lamented that they were rushed and had to do all this very quickly. So let's read the decision. And I'm going to have to go shortly. This is going to be kind of from the middle of it. At the heart of the First Amendment lies the principle that each person should decide for himself or herself that the ideas and beliefs deserving of expression, consideration, and adherence. Government action that suppresses speech because of its message contravenes this essential right. Content-based laws, those that target speech based on its communicative content, are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve a compelling state interest. Content-neutral laws, in contrast, are subject to an intermediate level of scrutiny because, in most cases, they pose a less substantial risk of excising certain ideas or viewpoints from the public dialogue. This is the conversation. The first question in the case is what level of scrutiny applies, and it matters because to clear strict scrutiny, that's the highest level of scrutiny that a law would have to clear. You basically start from the position that the law is unconstitutional, and the government has to overcome that by saying it is constitutional because it serves this very compelling government interest. It's narrowly tailored to that interest, and there are no alternative ways that actually advance that compelling government interest. There can be no alternative, less restrictive means in order to survive strict scrutiny. So the reason why there was an argument that strict scrutiny applies is because, TikTok wanted to say the government can't clear this really high hurdle. The court decided to apply intermediate scrutiny, something less than that. So they're not willing to go so far as to say that this law directly implicates your right to speak or freedom of expression. And that comes from the early part of the conversation during oral argument, where the justices were saying this doesn't even have to do with speech at all. As the Chief Justice says, Congress doesn't care what's said on TikTok or what TikTok does. They care about who owns TikTok, and this is about the ownership. And so that's what they're basically saying in their decision here to apply intermediate scrutiny. This is not a direct impingement on freedom of expression, but it's something kind of murkier than that, and it really has to do with the ownership structure. I'm just going to continue reading. Content-based laws and those that content-based laws, those that target speech based on I just did that. Okay. We have identified two forms of content-based speech regulation. First, a law is content-based if on its face it applies to a particular speech because of topic discussed or the idea or message expressed. Meaning you can't tell someone you can't pass a law saying, you can't talk about hot dogs, or David in particular can't talk about anything, restricting the person's speech or restricting a particular type subject matter. Second, a facially content-neutral law that is nonetheless treated as a content-based regulation of speech if it cannot be justified without reference to the content of the regulated speech or was adopted by the government because of disagreement with the message the speech conveys. As applied to petitioners, the challenge provisions are facially content neutral and are justified by a content neutral rationale. This is interesting because part of the rationale for the law was that there could be content manipulation, that China or ByteDance could somehow manipulate the algorithm in the United States, and that was part of the national security risk. And the justices pressed the Solicitor General during oral argument and said, how can you say that it's not a content-based law when content manipulation is literally one of your arguments? She did a pretty good two-step in there and danced and addressed the question, and it seems like they're kind of agreeing with that. They're saying that it's a content-neutral law, and it's based on a content-neutral rationale. So I'm not sure that they're actually getting to that justification. The challenge provisions are facially content-neutral. They impose TikTok-specific prohibitions due to a foreign adversary's control over the platform and make divestiture a prerequisite for the platform's continued operation in the United States. They do not target particular speech based upon its content, contrast, or regulate speech on its function or purpose, contrast. Nor do they impose a restriction, penalty, or burden by reason of the content on TikTok, a conclusion confirmed by the fact that petitioners cannot avoid or mitigate the effects of the act by altering their speech. So they're saying, we're not telling you can't speak on TikTok because you can continue to speak so long as a different company owns it. If you change your speech, that doesn't change your position here or help your argument at all. So it's not actually targeting your speech. That's what they're saying. As to petitioners, the act does not facially regulate particular speech because of the topic discussed or the idea of the message expressed. Petitioners argue that the act is content based on its face because it excludes from the definition of covered company any company that operates an application. That's a less important argument. We can skip that. The government also supports the challenge provisions with a content-neutral justification, preventing China from collecting vast amounts of sensitive data on 170 million U.S. TikTok users. That rationale is decidedly content agnostic. It neither references the content of the speech on TikTok nor reflects disagreements with the message that such speech conveys. Because the data collection justification reflects a purpose unrelated to the content of expression, it is content neutral. So they're going with the government's justification that this is about data collection, not about content manipulation. The Act's TikTok-specific distinctions, moreover, do not trigger strict scrutiny. It is true that speech restrictions based on the identity of the speaker are all too often simply a means to control content, or among different speakers within a single medium often present serious First Amendment concerns. For that reason, regulations that discriminate among media or among different speakers within a certain medium often present serious First Amendment concerns. I'm going to pause and see if there are questions that anybody has while I'm continuing to read.
Yeah, so I think
Okay, I don't see. I'm just going to keep reading. Let's check out the other concurrences. So we did Sotomayor, who says this law, I don't know why we assumed without deciding that this law implicates the First Amendment. It definitely implicates the First Amendment. TikTok engages in expressive activity by compiling and curating materials on its platform. Basically, they're like, a newspaper. That's what Justice Sotomayor said. Justice Gorsuch lamenting they had to do it so quickly. He said the court rightly refrains from endorsing the government's asserted interest in preventing the covert manipulation of content as a justification for the law before us. One man's covert content manipulation is another man's editorial discretion. He brought this up during oral argument too. They're basically just putting aside the government's justification that there could be covert content manipulation because that's a very thorny issue, because it could mean that it is a content-based reason for passing the law. And as Justice the danger of that and why we guard against it is because, as Justice Gorsuch is saying, one man's covert content manipulation is another man's editorial discretion. That who is to decide whether it's content manipulation or it's an editorial choice? And the whole point is we want to protect that choice and that expression through the First Amendment. Journalists, publishers, and speakers of all kinds routinely make less than transparent judgments about what stories to tell and how to tell them. Without question, the First Amendment has much to say about the right to make those choices. It makes no difference that Americans, like TikTok Inc. and many of its users, may wish to make decisions about what they say in concert with a foreign adversary. Those who won our independence knew the vital importance of the freedom as to think as you will and to speak as you think, as well as the dangers that come with repressing the free flow of ideas. They knew, too, that except in the most extreme situations, the fitting remedy for evil counsels is good ones. This is a hallmark of First Amendment law, that the remedy for bad speech or problematic speech is more speech. It's never trying to limit the bad speech. It's always allowing the free flow of speech. So the answer to bad speech is more speech, not restricting speech. That's a canon First Amendment principle. They knew, too, that except in the most extreme situations... Oh, wait, that's what he just said. Too often in recent years is how do people vote? Oh, Shannon's asking me. So it appears... I don't see a dissent. So it appears... Yeah, there is no dissent. So the justices voted by all accounts here, unanimously. It's a 9-0 opinion because there's no dissent. But they did it per curiam, which means no particular justice wrote it. They spoke with one voice. So this is a 9-0 opinion. This is unanimous, for those who are asking. Thank you, Shannon, for texting me. I can see that on my phone. I was just reading through Justice Gorsuch's. Second, I am pleased that the court declines to consider the classified evidence the government has submitted to us but shielded from petitioners and their counsel. So one of the issues here is that the government said, here's some secret national security classified information. Justices, you can see it, but we're not going to show TikTok. We're not going to show the creators. That creates a serious asymmetry of information in a case that could be hugely problematic. But the justice is saying here he's happy they didn't rely on any of that in reaching their ultimate decision. Efforts to inject secret evidence into judicial proceedings present obvious constitutional concerns. Usually the evidence used to prove the government's case must be disclosed to the individual so that he has the opportunity to show that it is untrue. Maybe there's a way to handle classified evidence that would afford a similar opportunity in cases like these. Maybe, too, Congress or even the Standing Committee on Rules of Practice and Procedure would profit from considering the question. But as the court recognizes, we have no business considering the government's secret evidence here. He kind of said that during oral argument, too. He was like, maybe you should go talk to your friends about this idea of using secret evidence because it's not really fair and could potentially raise constitutional issues about TikTok and the creators' ability to put forward their claims. Third, Justice Gorsuch says, I harbor serious reservations about whether the law before us is content neutral and thus escapes strict scrutiny. Interesting. See, I said Justice Gorsuch and Justice Kagan gave the Solicitor General a very hard time during oral argument, so he's hesitant about that. More than that, while I do not doubt that the various tiers of scrutiny discussed in our case law, rational basis, strict scrutiny, something in between, can help focus our analysis, I worry that litigation over them can sometimes take on a life of its own and do more to obscure than clarify the ultimate constitutional question. So what Gorsuch is doing here is he's concurring in the judgment, which means he's concurring in the bottom line, the ultimate conclusion. He is not concurring in all of the court's explanation and rationale, and that's why he's writing separately. So he concurs in the bottom line, but he's not joining the full per curiam opinion necessarily. He wants to write separately. Fourth, he says, whatever the appropriate tier of scrutiny, I am persuaded that the law before us seeks to serve a compelling interest, preventing a foreign country designated by Congress and the President as an adversary of our nation from harvesting vast troves of personal information about tens of millions of Americans. The record before us establishes that TikTok mines data both from TikTok users and about millions of others who do not consent to share their information. According to the Federal Bureau of Investigation, TikTok can access any data stored in a consenting user's contact list, including names, photos, and other personal information about unconsenting third parties. And because the record shows that the People's Republic of China can require TikTok's parent company to cooperate with its efforts to obtain personal data, there is little to stop all that information from ending up in the hands of a designated foreign adversary. The PRC may then use that information to build dossiers for blackmail, conduct corporate espionage, or advance intelligence operations. To be sure, assessing exactly what a foreign adversary may do in the future implicates delicate and complex judgments about foreign affairs and requires large elements of prophecy. But the record the government has amassed in these cases after years of study supplies compelling reason for concern. Finally, Gorsuch says the law before us also appears appropriately tailored to the problem it seeks to address. So he's basically saying, even if we applied strict scrutiny, I think it would survive strict scrutiny here. Even if it's he thinks it might be content-based or with a content-based justification, which would trigger strict scrutiny, but he's saying, I think that it would survive strict scrutiny. Without doubt, the remedy Congress and the President chose here is dramatic. The law may require TikTok's parent company to divest or effectively shutter its U.S. operations, but before seeking to impose that remedy, the coordinate branches spent years of negotiations with TikTok, exploring alternatives, and ultimately found them wanting. And from what I can glean from the record, the judgment was well-founded. Consider some of the alternatives. Start with our usual and preferred remedy under the First Amendment, more speech. Haha, I told you. However helpful that might be, the record shows that warning users of the risks associated with giving their data to a foreign adversary-controlled application would do nothing to protect non-users' data. So the canon First Amendment principle, more speech is the answer. The idea here would be that there would be some sort of warning or disclosure before you download TikTok telling you, they would have access to your data. But he's saying that wouldn't cut it. However helpful that might be, the record shows that the warning users of the risks associated with giving their data to a foreign adversary-controlled application would do nothing to protect non-users' data. Forbidding TikTok's domestic operations from sending sensitive data abroad might seem another option, but even if Congress were to impose serious criminal penalties on domestic TikTok employees who violate a data sharing ban, the record suggests that would do little to deter the PRC from exploiting TikTok to steal Americans' data. The record also indicates that the size and complexity of TikTok's underlying software may make it impossible for law enforcement to detect violations. Even setting all these challenges aside, any new compliance regime could raise separate constitutional concerns, for instance, by requiring the government to surveil Americans' data to ensure that it isn't illicitly flowing overseas. Whether the law will succeed in achieving its ends, I do not know. A determined foreign adversary may just seek to replace one law surveillance application with another. As time passes, the threats evolve, less dramatic and more effective solutions may emerge. Even what might happen next to TikTok remains unclear. But the question we face today is not the law's wisdom, only its constitutionality. Given just a handful of days after oral arguments to issue an opinion, he complains again about the very short timeline. Fair enough. I cannot profess the kind of certainty I would like to have about the arguments and record before us. All I can say is that at this time and under these constraints, the problem appears real and the response to it not unconstitutional. As persuaded as I am of the wisdom of Justice Brandeis in Whitney and Justice Holmes in Abrams, their cases are not ours. Speaking with and in favor of a foreign adversary is one thing. Allowing a foreign adversary to spy on Americans is another. And that is his final word on the matter. All right, there we are. How long do they have to sell? So the question about, there's a 90-day provision in the law that allows the president to pause enforcement of the ban if there is a viable deal on the table. I think that's what one person in Trump's camp was talking about in the media. But I think they have to have a viable deal on the table. But definition of viable is in the eye of the beholder, I guess, and that'll be up to the Trump administration. That would be 90 days. But he also has both houses of Congress, so perhaps there's some sort of, he could certainly try and push a repeal, but it had a lot of bipartisan support, so I'm not even sure that that would be an option. And once the law is on the books, like even if he reaches a deal, the law is still on the books, so he has to do something with the law, repeal it, or I don't know. It's complicated. Somebody said Katie something. Katie, so is there no hope? No, I think there's still hope. I still think at the end of the day it's going to continue to exist in some form or fashion. It's just, I think that the presidential administrations, both of them, are going to have to speak more clearly about the enforcement. They're going to have to put out a clear statement. Oh, did they rule on TikTok creators? Yes, they're saying both TikTok and the creators. I believe that it is part and parcel. They're not separating the two. I know there was some discussion about whether the creators could win or would have a better argument than TikTok, but they're saying the law does not violate the First Amendment rights of either the creators or TikTok. There are no other opinions today. Good question. I didn't tell you the R number right away because we all just dove in on the first opinion, but it is the only opinion of the day. Trump can pause the law. Not likely to sell, so if they stick with that, is it over? We still have a chance. It can still very well continue to exist. There are just some things that have to happen first. the companies who provide all the services that they would get fined for providing to TikTok have to feel confident that both Biden and Trump would not enforce the law against them. Which I think Trump is signaling, but signaling I don't think is going to be enough. But even the Biden administration's lawyer was saying, if you say we're not going to enforce the law and then you enforce the law, that TikTok would have some real due process issues, and they would be able to argue that in court. So it's good that we're progressing towards this non-enforcement. They just need to speak more clearly about it, I think. I don't have YouTube, but maybe I'll start it. I will go live for opinions no matter what. We always go live for opinions. I will figure out what platform we go live on if for some reason TikTok doesn't exist. But I think it's going to keep existing.
They probably won't take us again, will they?
No, they're not going to take us again. I can give you my IFD. You're welcome. Welcome to all the newbies. This is what we always do on Opinion Days. It's fun. There are a lot of fun opinions, interesting opinions, terrible opinions. Not terribly written, but sad for some people. Oh. But this is what we do every time the Supreme Court releases opinions, so you should join us, not just when it's about TikTok. Yes, I'm in DC. Yes, I'm a lawyer. Yes, I'm a reporter. You're welcome, guys. I'm probably going to go shortly, but I'm happy to answer any more questions. I think there's definitely still hope. There just needs to be some clarifications. Thank you, Shan. So the bottom line is the Supreme Court's upholding the DC Circuit. They're affirming the DC Circuit. They're upholding the law. Thank you. Put these on. Can a tribal council block it? Oh yeah, several of you have been asking that. I have no idea the answer to that question. I wish I did. I don't know if the app's going to go dark on Sunday. I don't think so. Can he do an executive order? Maybe. Like maybe there's some sort of non-enforcement executive order. Maybe. I'm not exactly sure how that would work because it's a federal law on the books. So it's complicated on how they're going to handle it. Who authored the opinion? So it was per curiam, Justice per curiam. There is no Justice per curiam. It's just all the justices unanimously speaking with one voice. Justice Sotomayor and Justice Gorsuch wrote separately to agree with the ultimate decision. I'm good if you want to take off. Yeah, I'll see you later. Okay, see you. I'm headed back to the station shortly. Thank you. Okay. Yeah, unanimous, meaning it was 9-0. But when the court, especially in this rushed way, they probably had everyone working on pieces of it. They're speaking collectively with one voice, and it's not one single justice who wrote it. But Justice Gorsuch said, I'm agreeing with the ultimate conclusion of the court here. I'm concurring in the judgment, but I'm not concurring in the rationale. So I'm going to write separately with his four. Actually, I think he had 5 separate points. And Justice Sotomayor also concurred to say, I don't know why we're assuming without deciding that this implicates the First Amendment. It definitely implicates the First Amendment. This is clearly a First Amendment issue. But the per curiam, the majority said, we're not even going to deal with that, and they applied intermediate scrutiny.
I think so. I would be ready for
A lot of this is because the court had to move very quickly, which they can do, but they're not necessarily accustomed to doing. But they felt like obviously they needed to say something here and reach a resolution in this case, ultimately. Although, as we were saying, a non-decision would have been a decision too. Not putting anything out would have allowed the law to take effect. But clearly they wanted to make their statement that the law is constitutional. What is intermediate scrutiny? So there's rational basis, which means for the government to pass, for the law to pass constitutional muster, the government basically just has to have a rational basis for the law. Then there's strict scrutiny, which is the highest tier of scrutiny, where the government has to justify its law by saying there's no alternative way to achieve our compelling government interest here. This is the most narrowly tailored way to do it. And that's actually what Justice Gorsuch was saying, is that even if we applied strict scrutiny here, I think that, okay, thanks. Even if we applied strict scrutiny here, that I think it passes constitutional muster under strict scrutiny. So, an intermediate scrutiny is something in between where it's a bit malleable, but it's, there needs to be a compelling government interest. The government needs to justify it, but it doesn't need to be the most narrowly tailored way of achieving that interest. And the reason why something would trigger strict scrutiny is on its face, it would directly target speech or the speaker, and the Supreme Court is saying, oh, that's very kind. Oh, very kind. It's very nice. Somebody wrote me a nice note, said he enjoyed watching me work. It's very sweet. So hopefully that answers your question about intermediate scrutiny. The bill of attainder argument didn't get raised in this case because the Supreme Court only granted the First Amendment question. So the bill of attainder argument is that Congress is not allowed to pass a law punishing a person or a company without due process, without a trial, without legal process. And so there was an argument here that Congress was punishing TikTok, Inc., but the Supreme Court didn't agree to answer that question. Thank you, Shan. SCOTUSblog.com, yes. We do a live blog too, but I'll be here. I'll be live somewhere for opinions, don't you worry. That's a good question, what time Sunday? It's probably midnight. I don't know if the law has a time, but it's probably midnight Saturday night. Which is why everybody's saying there's 36 hours of the Biden administration, because it would be the 24 hours of Sunday plus the 12 hours before noon, which, by the way, on Inauguration Day, like, even if the president isn't sworn in by noon, the power goes to him at noon no matter what. That's a constitutional thing. He becomes president at noon, even if he isn't sworn in yet. Can a president overwrite a Supreme Court decision? No. But there are some things that can be done, like it is the president's job to see that the laws are faithfully executed. It's his job to enforce them. And so he could choose not to enforce this one, which it sounds like that's what we're headed towards. But there are some tricky issues that also creates for the companies who would be subject to the law. So no, a president can't override a Supreme Court decision, but I think there's some wiggle room and things that can be done. Do I know how the justices voted? They voted 9-0 to uphold the law.
How are we doing? You good, Jason? You good shape?
There were no dissents today. All right, guys, I'm going to take off. I'm going to go do my other job. I hope you all have a wonderful day. I think we're still going to be here.
Back in a minute, you can
You're welcome. Thank you all. You're welcome. We always do this for Supreme Court opinions. I'm just saying. You could join us for other opinion days. There's some interesting cases this term.
It was so much colder.
All right. Thank you, guys. Have a great weekend. Everybody take a deep breath. there's still some hope.
I kept with them saying it's fine.
That was an example that Justice Kagan used to